Especially over the last, well, ever since the 1960s, there has actually been a cottage industry, a disinformation campaign to claim that a convention for proposing amendments is something that it's not. The argument goes that the convention for proposing amendments is really a constitutional convention that could propose anything it wants, it's inherently uncontrollable, and it could ultimately be a junta that takes over the country. It's really interesting that the people who mostly propose that line today are people on the right, but the actual story became publicized by people on the left. The story originated as a result of a campaign by people around Senator Joe Tidings and Bobby Kennedy in the 1960s to stop a campaign to adopt some conservative constitutional amendments. And unfortunately, it's been picked up by people on the right. So there's been a tremendous amount of disinformation and confusion over this, which is one of the reasons why I talk on this subject.
Just real quick, dispel the myth of the runaway convention and how an Article 5 cannot turn into a quote-unquote runaway convention, because I run into that an awful lot.
Yeah, okay. The runaway convention myth is the one that I just alluded to, the idea that, that this convention can declare itself the supreme power and do anything it wants. Each of these convention delegates is first off, the convention is called to deal with particular problems. The particular problems are identified in the applications. If the application says this is for a convention to consider a balanced budget amendment, that's the limit of the scope of the convention. If the convention goes beyond that, then you've got multiple fail-safe devices to prevent it from doing so. For example, somebody could sue. A lawsuit could be brought against any proposed constitutional amendment that was not within the power of the...
And that.
Or there could be an alarm of some kind.
They can only propose and not dispose, right?
Well, we're coming to that. Any amendment that the convention came up with that's outside their powers is not a valid amendment, and the courts could so hold. Congress could refuse to set a mode of ratification for such an amendment. Remember, Congress chooses whether ratification is going to be by the state legislatures or by state conventions. Congress, I can assure you, would be all too happy to block the convention process if it had the pretext for doing so. Any amendment has to go to the states for ratification. You need 3/4 of the states to ratify. If the ratification is by state legislatures, that means that what? 13 legislatures out of the 13 legislative bodies out of the 99 legislative bodies, 49 bicameral legislatures and 1 unicameral legislature, only 13 legislative bodies could block any particular amendment. Even if an amendment were approved, again, the courts could intervene and declare it not validly ratified if it's not validly proposed. Now, one of the responses that comes back to this invariably is the following. Well, you know, the lessons of history are against you, Nadelson. Why is that? Well, look what happened in 1787. Isn't it true that the convention of 1787 was called by Congress for the exclusive purpose of amending the Articles of Confederation? And they disregarded their limits, and they went and they wrote a whole new document instead. Isn't that true? Anybody ever hear that?
Oh, yeah.
It's false. Here's what actually happened. First, Congress didn't call the Constitutional Convention. The Constitutional Convention was called on the same day by the states of Virginia and New Jersey. It was called at the request of the Annapolis Convention that had met the previous year. Congress did not call the Constitutional Convention. Secondly, upon the call by New Jersey and Virginia, 7 different states decided that they were going to participate, and those 7 states appointed their commissioners and wrote their commissions in a way that would permit the commissioners to recommend an entirely new document. After 7 states had done this, Congress decided it was going to endorse the effort. In Congress, 2 states, Massachusetts and New York, objected and said, hey, we don't want this convention doing anything but amending the Articles of Confederation. And so Congress passed a really weak resolution that basically said something like, it's the opinion of Congress, not even a recommendation, it's the opinion of Congress that this convention ought to meet for the purpose of amending the Articles of Confederation. But you see, Congress had no authority in the matter. And so those 7 states that granted their delegates power to write an entirely new document, not one of them changed that power. And then that left 6 states. One, Rhode Island, decided not to participate, and of the other 5, 3 of them disregarded Congress, the non-binding opinion of Congress, and went ahead and authorized their delegates to recommend an entirely new document. Of the 55 delegates, in other words, 48 of them had full power to recommend a new document, and of the 7 who did not, most of them didn't sign. So the charge that the Constitutional Convention exceeded its power is really a slander that goes back to the days of the Anti-Federalists, the opponents of the Constitution, who used that as one of their arguments to oppose the Constitution. The fact is that the founders were honorable men, and they operated with only 1 or 2 exceptions within the limits of their power. So Exhibit A for the claim that a convention can run away is the claim that the 1787 convention ran away, and in fact, historically, is not true.